need to be encouraging people, encouraging our students, encouraging our children, encouraging our friends and colleagues, and encouraging our pastors and teachers to abandon, give up on this misguided idea that feeling is a reliable guide to truth and return to the principles of faith and reason.
Well, of course, Thomas Reed's old line is that if it were a matter of feeling, then judges are ill-named. They should be called feelers. They should be called feelers, yeah. Right? And of course, there's the great mystery passage, my right to make up my own version of the universe. And in that construction, you and your rights have no place. Here we are at the Natural Law Moment. We're having a podcast today on the new book by our friend Robby George on Seeking Truth and Speaking Truth, the new book with Encounter Books. Gerry Bradley's with me. Gerry's in South Bend. Robby's and here I am in Princeton. Now the story is, why am I in Princeton? As Damon Runyon says, a story goes with that. Riding between Amherst and Washington in the summers, I used to stop in Princeton in early July to have early July birthdays with Robby and Cindy. All of us are born early July. I'm the 7th, Robby's the 10th. His son David was born on the 11th, and Cindy was the 18th. So we stop in and we have these birthdays. So this year we couldn't do it. This time they're having what Dan Robinson used to call a birthday with a zero in it. Okay, so this was worth doing, and it turns out three George sons were born in July. So Joe and Catherine knew how to deliver 3 boys in July. They had no truck with Planned Parenthood, but they had the craft of delivering 3 boys in July. It's remarkable. So we're here to do this. And we have a number of things to work on. I'm trying to get to the center of Robby's book, but I was telling Robby the other night of a story that touched one of his central concerns. It was with the late comic, Jackie Mason, during the link to the Kennedy-Nixon election, affecting to speak for Nixon, telling the audience, it's very important for you to vote. If your conscience tells you to vote for Mr. Kennedy and you want to vote for me, well, let your conscience vote for Kennedy and you vote for me. And of course, you expect, when the comics do this, the laugh is a sign that the audience got it. It's backing into dualism. And that's a central point for Robby, it running through many of his points. But how people suddenly back into dualism without noticing. No, that's really not Uncle. That body you see is not really Uncle Julius. We know the real Uncle Julius, and we don't want to sustain the one we have at hand. But let's go to the center of the thing, touching those concerns that have really animated Gerry and me, and they're really at the center of the book. The question of the human person, the rights-bearing being. Why do we impute dignity to that being? We have conservative judges now think that they can't quite give us an account of who is that human being, who's the object of the law's protection. The whole regime begins with the notion that we know what that human person is, that biped somewhere between angels and gods, angels and animals, that he has rights that flow to him by nature as a human being, and the telos, the very purpose of this government, is not to invent new rights, but to secure and enlarge those rights that flow to him by nature. And yet, our friend Scalia said, the law can't give us an answer to the question of what is a human being. Gerry has written on this, and we both come down severely on him for that. That is a value judgment, he said. That's something that turns on whether we're going to impute value to him. Lincoln said at the time, the question is whether the black man is or is not a human being. If he's not a human being, then he who is a human being may do to him what he wishes. But if he is a human being, he too would have the right to govern himself. And our late friend Harry Jaffa said, that cannot be a value judgment of whether the black man is a human being. And Gerry and I, and you've been taking the line, that question of what the human being, that can't be a value judgment either. And yet, some of our friends as Brett Kavanaugh, think that somehow that question is beyond his job description. And so, Robby, you were disappointed that the court in Dobbs did not pick up on the marvelous brief you'd written with our friend John Finnis and protecting the child. They won't recognize the standing of the child. What do you make of the friends among conservative judges who cannot quite think they can reach that question? They're in a position to speak about that question of what constitutes that human person who's the object of the law's protection. What's your own reading of that?
Well, first, Hadley, let me say what a privilege it is to be on this podcast with you and our dear old friend, Gerry Bradley. I want to thank Garrett Snedeker, my former student and yours, for setting up this podcast. Well, the 14th Amendment to the Constitution, one of the three amendments enacted after the Civil War, fundamentally to ensure and secure the rights of the former slaves. The 14th Amendment says in pertinent part that no state shall deny any person of life, liberty, or property without due process of law, or deny to any person within their jurisdiction the equal protection of the laws. Now, that simply then leaves the question, okay, who counts as a person? The current dominant movement in the conservative world of jurisprudence is one that lays emphasis on the original public meaning of terms in trying to give effect to constitutional guarantees, such as the due process and equal protection clauses of the 14th Amendment. Therefore, Professor Finnis and I, in our brief to the court, which appears as a chapter, it's further developed and appears as a chapter in the new book, Seeking Truth and Speaking Truth. Therefore, Professor Finnis and I went to historical sources to determine what the original public meaning of the term person was at the time of the ratification of the 14th Amendment. What did the framers and ratifiers, most pertinently the ratifiers, who as ratifiers change ideas from being just ideas into actually being binding law, what did the framers and especially the ratifiers mean by person? Did person include those human beings in the womb prior to birth? And in the brief, we established by, I think it's fair to say, Gerry Bradley can correct me if I'm wrong, I think it's fair to say we established by an avalanche of evidence drawn from cases, from treatises, from medical publications, an avalanche of evidence establishing beyond any possible doubt. We could meet the standard of proof of the criminal law here beyond any reasonable doubt that for the ratifiers of the 14th Amendment, the term person included the child hidden in the womb. It included the unborn child. It included all whole living members of the human species, whether they are in the embryonic, in the fetal, in the infant, in the child, in the adolescent, or in the adult stages, whether they're healthy or suffering and ill, whether they're poor or weak, whether they're of this race or that race. Every living member of the human family is a person by reference to the original meaning of the term as it appears in the 14th Amendment. The court did not expressly reject that idea, but they didn't adopt it. They didn't really address at the end of the day the argument that Professor Finnis and I put forward in our brief. I'm hoping, Hadley, I retain the hope that the day will come when they will address it. I think it's important that, with the exception of one Justice, Brett Kavanaugh, none of the other justices, including those in the majority, of course, none of the other justices offered an opinion as to whether the sound, correct interpretation of the 14th Amendment is one that would bring the protections of the amendment to the child in the womb. So I continue to hold out hope that the day will come. So far, all the court has done is reverse Roe versus Wade, which returns the issue to the legislative domain, but they haven't foreclosed the possibility that in the future they'll do what I think the Constitution does actually require if we interpret the terms by reference to their original public meaning, and that is protect
Okay,
the
but
child.
now before Gerry's going to jump in here too. Now, of course, you and I would probably argue that even if we didn't have the historical record, some of the conservative judges look to the historical record for the sake of avoiding making a moral judgment now. And I think you and I would look at this now, even if we didn't have the historical record, we'd have enough evidence from embryology woven with principled reasoning to give us the ground to protect the child. But you played it out in the terms they understood. You took the line, okay, we're going to look at the historical record, look at it very closely. Kavanaugh was, I think, the price that Alito had to pay to get that fifth vote to overturn Roe versus Wade. But let's say, Robby, you played it along the lines of their prescription. You took the historical view, and yet they held back. And why do you think? What's the rationale for holding back? What do you think is the understanding for holding back about the people who held back, like Kavanaugh?
I think it's that they thought actually doing what we showed, what Professor Finnis and I showed the 14th Amendment requires, would be too much too quickly. The public couldn't handle it, wouldn't support it, that there was not sufficient public support for it. But I'll tell you something, Hadley, short of the court actually giving full effect to the meaning of the Equal Protection Clause in this context, if you look at Section 5 of the 14th Amendment, as Gerry well knows, and I'm sure you do too, that's a section that confers upon Congress, explicitly confers upon Congress, the power to enforce the guarantees of the other parts of the amendment, including Section 1, where the due process and equal protection clauses are to be found. So it is right now fully within the authority of Congress. In fact, I would say it's actually primarily, even before you get to the courts, it's primarily the obligation of Congress to decide what the term person actually means, to whom it extends. And if they do that and do it in a fair and rigorous way, they will enact legislation to protect the child in the womb, exercising a new delegated power they got with the 14th Amendment under Section 5.
So I go over to Jim, but let's just make this point that, in fact, you could do it right now. That well, listen. Let me wave this over to Gerry. It seems to me that you could. What is it that holds? What is it holds them back? You could say they understand what the core of the matter is, but they think the public isn't ready to understand it. I doubt that. But on the other hand, the question is, can you really give an account of what's at issue in this case without explaining that the core of the matter is that we're dealing with the taking of a small human life? And how does one give a coherent account of what we're doing if you're reluctant to explain that matter at the core of it? But let me yield to Gerry for all just picking up on these lines.
Well, I think you're quite right, Robby. Let me mention two things in particular that you said that bear emphasis, and I think strong emphasis. One is that although, and this is me speaking and not something that you mentioned, there's rhetoric, there's expression, there are sentences in Dobbs which very strongly suggest that the court has decided that the unborn are not persons. These would be expressions to the effect, well, some states may decide to have pro-life laws and some states may decide to have pro-choice laws, and we're not taking a side in that. And that rhetoric may be part of the price that Hadley mentioned to get Brett Kavanaugh to sign on as the fifth justice. My own guess, and this is an educated outsider's guess, is that keeping Brett Kavanaugh from joining Roberts' concurrence was probably a touch and go at several points during the development of the majority opinion. And I do think that it was essential that there be an opinion for the court in Dobbs. So I don't fault Sam Alito or anybody for paying whatever price Brett Kavanaugh set on his vote. But when you analyze Dobbs as a lawyer should analyze it, the court does not hold that the unborn are not persons. Indeed, the court, I think quite consciously and deftly, is holding that matter open for future resolution, perhaps by the Supreme Court, but also, as you say, holding it open to Congress to act on what the court in Dobbs says is more properly a legislative judgment about when people begin. So in a way, Dobbs has teed it up for Congress in a very, apt way. And I do think you're quite right that under Section 5, Congress has the authority to legislate in favor of unborn life. Whether Congress to do that, they would be if they understood what you're saying and took it on board, they would be relieved of the awkwardness of having to defend unborn life, protect unborn lives on the basis of the Commerce Clause, which is probably what they think they need to do. But they could do so on the basis of the human rights really affirmed in Section 1 of the 14th Amendment and the power to enforce those in Section 5. Now, it may well be that there isn't much political will to do that right now in Congress, but Congress will change in 15 months from now. But the point is that Congress could do that. It would be constitutional if they did do that. And I think when you think about how any eventual pro-life constitutional victory would play out, I think it's important to remember, although what the Supreme Court does is obviously very important and in a way central, but to truly protect unborn people and to accord unborn people the equal protection of the laws and to accord them that protection even in states which are politically unfriendly to the unborn, I don't think courts actually can do that. I think the battle over equal protection of the unborn is one that has to be fought in the end by Congress, in much the same way that the battle over civil rights for Black Americans really was only won, let's put it this way, was only won, not with Brown, but with the Civil Rights Act and the Voting Act of 1964 and 1965. So I think that there's an essential role that Congress has to play in this fight over protecting the unborn. And you're quite right that that's really where the action will finally be.
Nothing, of course, is as powerful as Congress intervening with the Civil Rights Act, an act that established that principle going prospectively for all businesses similarly situated. But it took 10 years of the court teaching the wrongness of racial segregation to reach that point. And it may need the court to once again to act as Republican schoolmaster, to start putting a new ethic into place. And I think they turned away from that in Dobbs. But I just want to be clear. I want to be clear on one point that comes away from your earlier remarks, Robby. In other words, you don't think there's anything in the job description of the justice which prevents the judge from recognizing that critical point that we're dealing in abortion with a human being, and that's at the center of the problem. The grounds which you justify the taking of a life of a human being. There's nothing about that falls outside. Kavanaugh thinks it does. He thinks it's one of those issues of policy, like that was not in his job description, should lie someplace else. But again, from what you say, you don't think that lies outside the reach of judges.
I'm sort of not sure what the question is, Hadley. What do you mean by within the job description?
Kavanaugh said, is it interesting? Some pro-lifers actually believe the unborn, that if offspring in the womb is human. They actually believe it as though we don't have a long record of
well, that's a matter of
biology.
That's a matter of biological fact.
That's right. Yeah. But he doesn't want to keep. He's acting as though we don't have the kind of evidence.
Yeah, I mean, if there were any real doubt about it, there is no real doubt about it. But if there were any real debate about it, the court could ask for the question to be briefed.
Yeah. Now, let me put Hadley's. I'll take a run at putting Hadley's question in this light most favorable to we're calling it Brett Kavanaugh's position, but let's just call it a position. It's the Scalia
position. I think what you're pointing to here is Justice Scalia's position that the Constitution is silent,
which is
on the question of the status of life in the womb.
Exactly, and that's exactly Kavanaugh's position as well. Right?
Correct. I mean, it seems like this position that we're discussing, whether it's Justice Scalia's or Justice Kavanaugh's or somebody else's, would work in the following way. Let's imagine the person who holds this position reads the brief, the magnificent brief, really, submitted by you and John Finnis in Dobbs, and reads it through and says, yep, they're right. I certainly can't think of any objection this person holding the position thinks, and I don't have any contrary evidence. I can't think of any evidence they haven't. They're right. But the problem is judges are not in the business of making decisions of that sort, that there's something in the nature of the judicial craft, judicial methodology, you might even say Article 3 judicial power, which precludes the practitioner of this judicial craft from making that sort of what I think this person would call value judgment. That there's you might call it a methodological trump, even over historical evidence. Now, I don't agree with this view, to say the least, but I think that is the position. Now,
well, the kernel of truth in the position, if I'm understanding it correctly, would be that there is such a thing. It's possible and real. There are such things as unjust laws, and there could be unjust provisions of the Constitution. And if you had a provision of the Constitution that was unjust, it would nevertheless be the legal duty of a judge to give effect to the unjust provision. But if the question is, does our law unjustly deny the humanity of the child in the womb? The answer to that is no, we have no such unjust law. There's nothing in the Constitution that declares the unborn to be non-persons or not human or what have you.
yeah. And it would be the duty of a judge to give judgment in accord with that evidence.
With the law. I mean, I think every judge has the experience of being required under the law to fulfill their judicial oath to give effect to a law which produces a result that in that case the judge believes is not only unfortunate but actually unjust. Just talk to any of our friends on the bench. They've all had that experience, but it is their duty. Now, in certain cases, the moral duty of a judge, not every case of an unjust law, but in certain cases, the moral duty of a judge would be to refuse to cooperate. But you do that not by lying about whether the law is unjust or whether that is in fact the law. You would do it by recusing yourself or even resigning from the bench in protest. Or just because, not even in protest, because you can't in good conscience participate in the giving effect to this particular unjust law.
Well, of course, back in Roe versus Wade, the lawyers for Texas really did lay out the case.
Yeah, oh yeah,
They did lay out
absolutely.
the case. They did. They could have acted on them. And although that exactly wasn't the matter that was briefed, when you and John wrote that brief, it made sense only if you thought the judges could indeed recognize the critical point you were making and incorporate it in their position. So I think their reluctance to do that, it's something that has to be explained in the Scalia-Kavanaugh reluctance to move into that domain.
Well, Hadley, it could have something to do with this. I'd be curious whether you think I'm right about this, Gerry, you too. Of course, the conservative legal movement, and for completely good reasons, embraced the concept going all the way back into the 60s when there was a kind of very nascent resistance to the really outrageous decisions in many cases of the Warren Court. The conservative legal movement embraced the idea of judicial restraint. When possible, leave matters to the legislature. Don't resolve matters in courtrooms where they're being resolved by unelected and electorally unaccountable judges, when they can be resolved by the elected representatives of the people. That's it. It's not a bad instinct at all. And there's obviously a strong element of truth in that. But that truth can be recognized while we at the same time recognize that it is fundamentally the obligation of the judge to give effect to the law. Now, sometimes what the legislature is doing or failing to do puts the legislature in violation of the law. And in that case, the judge, even at the risk of being deemed activist, has got to go in and say, no, it is not within the legislative power to do this, or the legislature has an obligation to do this, and we're going to enforce the law here. So judicial restraint is not a kind of moral absolute or some sort of ideal. Yeah, judges should, when they don't have a warrant for intervening in a legislative judgment, allow the legislative judgment to stand. That's our doctrine of the separation of powers and the distinction between the judicial and the legislative offices and roles. But where the law requires the judges to invalidate an act of the legislature, where the Constitution requires that, well, it's the obligation, the legal as well as the moral obligation of the judge to do that, even though you're displacing a majoritarian judgment.
Now, Robby, let me ask you something of even broader sweep, although not necessarily more important than what we're talking about. But in the author's preface to the book, you christen our age, after looking at the age of enlightenment or the age of science in the past, you christen our age, if I may use the word christen in this context, as the age of feeling. And I know in many of your writings, your scholarly writings as well as your more popular writings, you have used another term, which I think you treat as a synonym for feeling, the age of feeling, and that is expressive individualism. But is there a way for, I guess, readers of your book and those who follow your work to take this insight and this way of capturing the essence of our age? And how do you develop tools to fight back? Now, you could. It's a question about retail or wholesale counter-revolution, but it's true enough. You're quite right. It seems to be the age of expressive individualism and feeling, but it's such an overwhelming cultural fact. It's sometimes just not only discouraging, but hard to figure out, well, where do you begin to push back? For the listeners of our podcast, let's say for those who are not lawyers, where can they push back on the age of feeling and make little incursions into it?
Well, you're right, Gerry. I opened my book by pointing out that the historians are fond of breaking up the epochs, the eras, into the age of this and the age of that. And so they sometimes say the medieval period was the age of faith. Now, what do they mean by that? Well, they mean that for the medieval thinkers, for Christian thinkers like Anselm or Aquinas, Jewish thinkers like Maimonides, Muslim thinkers like Averroes or whoever, for these figures, the touchstone of truth and of goodness and of right and of justice is conformity with a faith, the Christian faith, the Jewish faith, the Islamic faith. Now, there's a strong element of truth in that. We need to be careful, though, not to be misled. We shouldn't interpret calling the medieval period the age of faith as meaning that the medievals were fideists who believed that the only source or sources of moral knowledge were those of scripture or revelation. No, the great medieval thinkers of all the traditions obviously believed in the importance of reason. They were practitioners of rationality, of rational argument, of rational inquiry. And nevertheless, there is some truth in the idea that in the medieval period, we're dealing with the age of faith. Well, these same historians tell us that in the Enlightenment era, in Europe, in Germany, and France, and Scotland, and England, in the Enlightened period, we have the age of reason, or sometimes the age of science. Now, what do they mean by that? Well, they mean that for the great Enlightenment thinkers, the touchstone of truth, of goodness, of rightness was conformity with the findings of rational inquiry, with rationality, with reason, with science. And again, there's truth in that, although we have to be careful not to be misled by it. It doesn't mean that all of the Enlightenment thinkers were hardcore secularists or atheists. Many were not. Begin the list with Newton, who was a devout Christian, as were many of the other great Enlightenment thinkers. Still, there's some truth in the idea that for Enlightenment thinkers, the touchstone of truth was rationality, and it was the age of reason. Well, if the medieval period was the age of faith and the Enlightenment era was the age of reason, in what age do we live? What do people today, not all people, but what do a lot of people, especially a lot of young people, treat as the touchstone of truth and of goodness and of justice and of rightness? Feeling. It's not reason. It's not faith. It's not, as I believe and you believe, and as the medieval thinkers believed, and as many of the Enlightenment thinkers believe, faith and reason. No, both faith and reason have been ditched as sources of knowledge, of truth, of wisdom. What do people, especially young people, many look to today as the touchstone of truth? Their feelings, their emotions. How do I feel about it? What's my emotional reaction to it? We've even fallen into the fallacy of believing, some people have fallen into the fallacy of believing that you're being even a man or a woman, male or female, boy or girl, depends on how you feel, not on some objective fact that is determinable by rational inquiry, scientific inquiry, biological inquiry. Now, is that good or bad? I say it's really, really bad. It's deeply pernicious. Why do I say that? Well, we frail, fallible, fallen human beings are going to make mistakes no matter what we teach as what we treat as the touchstone of truth and goodness and justice. Even trying our best to be reasonable, we'll sometimes fail. Even trying our best to be faithful to our traditions of religion, we're going to be sometimes get things wrong, or the religious tradition itself will get things wrong in some cases. But faith and reason, especially taken together, are a much more reliable source of knowledge, of truth, wisdom, goodness than feeling. Our feelings are spectacularly bad sources of information or wisdom or truth. They so easily lead us astray. We can so easily fall into believing that whatever we happen to want at the moment, whatever our emotional needs, our desires, our passions are, is of course right. That's what's true. And of course, this is the road to hell. We precisely need faith and reason as a check on wayward feeling, wayward emotion. Our aim should be not to be slaves of our passions, but should be self-mastery, to be masters of our desires, of our feelings. You rightly say, Gerry, that I sometimes use the term that I've gotten from the late sociologist Robert Bellah, the Berkeley sociologist Robert Bellah. I use the term or phrase expressive individualism. That's the same idea, that the right way to behave is, if it feels good, do it. To just act on your feelings, act on your emotions. How did Woody Allen put it, Hadley, when he was
The
caught in
heart
that
wants
affair?
what the heart
Yeah, the
wants.
heart wants what the heart wants. He was caught in an affair with his wife's adopted daughter, and he justifies it by saying the heart wants what the heart wants, as if the emotions can be a guide to what's actually right, wrong, good, bad, true, false. So my plea is for people to abandon the idea that feeling or emotion is a reliable source of truth. It's a spectacularly unreliable source, and to go back to examining what we should believe, what we should do, how we should act, how we should behave, by examining it by reference to the principles of faith and reason. For example, the principle of faith we get in Genesis 1, where we're told that man, the human being, though fashioned from mere dust of the earth, is nevertheless made in the image and likeness of God. This is the spiritual foundation of our belief in the profound, inherent, and equal dignity of each and every member of the human family. That is a much more reliable source of moral wisdom than whatever you happen to feel: anger, hurt, envy, whatever it is. Same with reason. What do we make, for example, of the status of that being developing in the womb? Is it a human being? Is it being? Oh, what is it? Well, here we rely on reason. Not on, we actually don't look to the Bible. We don't look up in the Bible, is a 7-day embryo a human being? Is a 6-month fetus a human being or a person? We don't get that, our knowledge of that, from the Bible. The Bible doesn't actually have an express teaching on that. We do it by science, by logic, by philosophical inquiry. The reason we know that the child, from the earliest moments, from conception forward, is a human being, is that we can establish by scientific methods that from the earliest embryonic stage, what you have there is a whole living member of the species Homo sapiens, a human being who will, by an internally directed process, if supplied with what anybody else needs to live, which is nutrition and a hospitable environment, develop himself or herself, sex being determined at the very beginning in the human being, from the embryonic into the fetal infant, child, and adolescent stages, and ultimately into adulthood with his or her determinateness and unity and identity fully intact. That's a rational inquiry leading to a rational judgment on the status of the unborn, which is obviously very important to the ethical question. So we need to be encouraging people, encouraging our students, encouraging our children, encouraging our friends and colleagues, and encouraging our pastors and teachers to abandon, give up on this misguided idea that feeling is a reliable guide to truth and return to the principles of faith and reason.
Of course, Thomas Reed's old line is that if it were a matter of feeling, then judges are ill-named. They should be called feelers. They should be called feelers,
Yeah.
right? And of course, there's the great mystery passage, my right to make up my own version of the universe. And in that construction, you and your rights have no place. And of course, this runs into the moral problem as soon as they are faced with the question, what if other people acted on your premise? But you touch there also that central matter of you bring dignity, while we impute dignity to that biped who conjugates verbs, and you touch something that was at the edge, but not fully incorporated in your position there. I remember being with a student of mine, a good student of mine. He came in one day and he told me he wasn't as enamored of natural rights as I am. And I said, why is that? And as the conversation moved, it settled on that character in the gutter who's broken his own life. And I said, why do we treat him nevertheless as a person with dignity? And then my former student, they'd be a kind of postmodernist song and dance. It's the lens by which we look at him. And I said, wait a minute, you're talking now about us. You stopped talking about him. Him. Why do we see him? Now you put your accent on as Leo XIII did, on a rational creature who can give reasons over rights and wrongs, can reason about rights and wrongs. And some of the people arguing about abortion said, well, these are not creatures who can actually enter into the conversation. Yeah. By that reckoning, you can end human life at 5 years old or something.
Yeah, that's right.
And sometimes they're 60 years old, you know. So you say it's what is contained in the capacity, and yet something else is at stake. And people say, well, they're not up to the same level. What seemed to be at work in your argument, I think, was the other part of it, Lincoln's argument, that nothing made in the graven image was sent into this world to be imputed, to be treated as a nothing, as though it didn't count. And I thought that becomes a critical part of your own argument, doesn't it, Robby, about the matter of the center of human dignity?
Yeah. So my view is this, that the basic foundation of our dignity as human beings is our rational nature, that we are creatures with a rational nature. What does that mean? That means we have agency. We're able freely to act on the basis of reasons that we can apprehend, intelligible reasons that we can intelligently grasp. This, I think, is what is meant by the biblical religious teaching that man is made in the very image and likeness of God. After all, it can't mean that God is like us in that he has 5 fingers on each of 2 hands and hair on his head and a nose. God's not a physical creature. God is spirit. So what can it mean? Well, how are we God-like, or how is God like us? Well, it's got to be this, that human beings, like God, as depicted, for example, in Genesis 1, are capable of freely acting on reasons. We can envisage states of affairs that do not exist. We can understand the intelligible point, the value of bringing them into existence. And then we can act freely on the basis of reasons, not just on instinct or impulse like a brute animal, to bring that state of affairs into existence. Now, that doesn't mean that we are entirely like God. Obviously, God is perfect. We're imperfect. God is infinite. We're finite. But what God has, according to the Jewish and Christian traditions, shared with us is some measure of divine power, of agency, of being able to act freely and on
Creative power.
reasons. And that's the source of our dignity. That's what makes us unlike even the most intelligent of the brute animals, dolphins, pigs, dogs, things like that, not just amoeba and spiders and so forth. So yeah, I mean, I think we can give a rational account of our dignity as human beings, and certain things in the ethical domain follow from that. There are certain things, certain ways you have to treat. You're required as a matter of reason to treat creatures who are bearers of profound, inherent, and equal dignity, including ourselves, actions with respect to ourselves, what John Stuart Mill called self-regarding actions. There are things we do not do to ourselves or with ourselves precisely because of our dignity as human beings, as
And
social creatures.
we don't allow self-murder. That grounds for taking your own life should be as compelling as the grounds for yours
That's right,
to
and he
take
can
any other
perfectly
life, right?
legitimately stop someone from injecting heroin into his veins, and jumping off a bridge, and things like that, because we respect the dignity of the human being. It's a mistake to run together dignity with personal autonomy in the contemporary sense of that term. The term autonomy has various meanings, but the way people tend to use it today, meaning the freedom to do what you want, whatever you want, whenever you want, with whoever you want. Our dignity is something distinct from that. Now, I do think our dignity does require respect for some measure of autonomy, but our dignity does not equate simply with autonomy, nor does
Well,
autonomy equate with our dignity.
that connects with your conversation and engagement with your professor Joe Raz at Oxford. And I never understood what his infatuation with autonomy was. But actually, would you tell the story about your encounter with him? It was an example of the British style of letting people know, the rest of the world, that they're not up to it. It's not up to our
Well,
class.
I owe an enormous
It's
amount to Professor Raz, and I'll be happy to tell the story. He was a great teacher, and I learned so much from him. But our our meeting was not our first meeting. Our initial meeting was not especially auspicious. I had arrived in Oxford. I had done my law degree at Harvard and was beginning my doctoral study at Oxford. And Professor Raz was my first supervisor. I was supervised by him and Professor Finnis, but Professor Finnis was on leave that first semester first term when I arrived, and my first meeting with the supervisor was Professor Raz. He left a nice note for me in my mailbox in my college, saying, please come along for your first tutorial meeting, actually called supervisions rather than tutorials at the graduate level, for your first supervision on a certain day at a certain time. I forget what it was, but he gave the date and time to come by his office, and he said, but a few days in advance, please drop a paper off in my box at Balliol College so that I can read your paper and then we'll discuss your paper. Well, I had a paper I was rather pleased with. If I recall correctly, it was on lawlessness and legalism that I had written at Harvard Law School. I'd gotten an A on the paper. I was proud of the paper. So I got that paper out and I worked further on it, tried to develop it further, enhance it. And I dropped the paper off at Professor Raz's box. And then at the appointed time, on the appointed day, I showed up at his office and knocked on his door, and he opened it, and I greeted him, he greeted me, and he sat me down and he said, now, Professor George, Robert, is it? And yes, Robert. He said, now, the paper that you've sent me, I've had a look at it. Now, this kind of thing would count as philosophy in a lot of places, but not in Oxford. This is not what philosophy is in Oxford. And of course, I was crushed. I mean, that was just devastating. I thought this was a really good paper. I'd gotten an A on it. Obviously, it counted as philosophy at Harvard, at least at Harvard Law School. So he could tell that, he'd hurt my feelings by that comment, or that I was in any event kind of stunned. And so he got out a blank sheet of paper and he drew a vertical line down the page. And he said, for your next project, here's what I want you to do. I want you to think of a proposition that people disagree about, that people argue about, people have different opinions about. It doesn't matter what the proposition is, just something in your general area of interest. And here on the left side of this line, I want you to write down all the reasons you can think of for believing the proposition. And on the right side of the line, I want you to think of all the reasons you can think of for disagreeing with the proposition. Well, that was my introduction to analytic philosophy, of which Raz was a master. But when we say analytic philosophy, Gerry, I think you'll back me up on this, we're really not doing anything very different from what Aquinas does. What does Aquinas do in his writings? He gets a philosophical question onto the table, and then he presents the very best arguments and reasons on one side, very best arguments and reasons on the other side. sorts his way through them, decides where he comes down, and explains why he comes down on this side rather than that side. Well, that's basically what Raz insisted that I do. And, before long, I had the zeal of the the zeal of the convert, and was a, was a very ferocious analytic philosopher. And most of my work, as you know, is in that analytic tradition to that day. So I'm grateful to Professor Raz for the teaching. It was a tough blow right there at the beginning, but I owe him a lot.
But he was an Israeli, but he cultivated this British arrogance. It's like Dad Robinson's line from when it went at Oxford, where the tutor says, "And do I take it your native language is English?" No. Now Raz was just enamored of the notion of autonomy. And we've seen what things Anthony Kennedy would do with the notion of autonomy. And I just thought, you had your differences, and I always said, what was the problem here? By autonomy, we simply meant a creature who had the active powers to act or forbear from acting. That is the ground on which we can hold him accountable for his acts. That's the ground on which he becomes a subject fit for the rule of law, and we cast judgments on it. So the fact you're autonomous means you could use your active powers to do rightful or wrongful things. But he was enamored of it, and how do you explain why he was so enamored of it? You were, of course, saw the problem with it right away. But what do you make of him being so enamored of that?
Well, Joseph and Professor Raz and I had a very long-standing debate on how we should think about autonomy and its role in moral and political philosophy and philosophy of law. Unlike me, Joseph came to believe that autonomy was actually a value, a reason for acting, and not just a value, but an intrinsic value, not a mere instrumental value, not something like money or insurance policies, but rather something like friendship or knowledge, something worthwhile for its own sake. Well, what did he mean by autonomy? Well, in his master work called The Morality of Law, The Morality of Freedom, the Morality of Law was L.L. Lon Fuller's book. Morality of Freedom was Joseph Raz's master work, published in 1986. Raz says, well, by autonomy, I mean being, to the extent possible, author of one's own life. And that, he thought, had intrinsic value. Now, I, both in our private conversations and in published writings, challenged him on this because it didn't seem to me quite sound as an understanding of autonomy. I understood autonomy to be what you just described it as being, related to the power of agency. And not a value as much as a condition for the realization of certain, or fuller realization of certain other values. So it really, to the extent that it could be classified along the instrumental intrinsic axis, it was instrumentally important, not intrinsically valuable. And to demonstrate this, and this is the fundamental reason I adopted my position, I came to my judgment, was it seemed to me that autonomy, if it were intrinsically valuable, would then have some value, whether it was exercised morally or immorally, in a morally upright way or a morally non-upright way, bad way. And I knew Joseph agreed with me that we could exercise our autonomy in an immoral fashion. I mean, Hitler acted autonomously, but he certainly acted in a gravely, shockingly immoral fashion. Joseph's response to this criticism, because it seemed to me that we wouldn't say, well, what Hitler did was really bad and he shouldn't have done it and it was terrible and it was dreadful. But there is one thing that came out of it, at least the intrinsic value of autonomy was realized. I just couldn't imagine saying that. It seems to me that there's no
And he was a
value
good dancer.
at all.
And he was a good dancer.
He was a good dancer, and he loved pets,
And the
and
fear
he
of us
didn't
is a good
smoke, and
dancer.
he was a
Yeah.
vegetarian. So Joseph responded by saying that he believed autonomy was intrinsically valuable. He insisted on that belief. He clung to that belief, but that it's only intrinsically valuable, indeed only valuable at all, if exercised for good ends, not for bad ends, and if exercised in a morally upright way. But that seemed to me to be completely satisfactory, and strengthened my belief that while autonomy has an importance and a role to play, it's not as a value, much less an intrinsic value. It is rather as a condition for the realization of certain other values. We need agency if we are to be agents, right? Moral agents.
Right,
And without that
right, right.
agency, we would be like zombies or like automatons. So that agency is a very important part of our moral life, but it's not itself an intrinsic value.
That's that fills in something so critically because that we saw what Anthony Kennedy did with autonomy when it came to same-sex marriage. And if we have time, that brings us back to something that's been very important for the three of us. If we have time to get it in, Garrett, um, we've all written about in opposition to same-sex marriage, and you especially have been eloquent, and Gerry been even more eloquent. You two have been eloquent in saying what the same-sex marriage is not. We must understand what a marriage really is at the very center of the problem. And the very telos of marriage, of sexuality, has to do with the begetting, bringing forth a new life. Now, in your book, there's an interesting passage in the chapter on Obergefell where you say, and that decision, you're critical of the decision Obergefell. You say, to reach that decision, the court had to take sides on normative and empirical disputes and policy choices in the face of reasonable and legitimate alternatives on which the Constitution is silent. That makes its decision on usurpation of authority vested constitutionally in the people and their representatives as not just by originalist logic. Now you say it is the Constitution is silent on the matter of marriage, but you've written eloquently on what a real marriage is. And is there any way you think the court could take account of not to say what the rightful form of marriage is? Even if, as you point out, as we point out years ago, as soon as you move away from the matter of begetting, the question will be, well, why is this relation confined to two? I mean, our love is extended in a wider field. And if you point out polyamory has arisen, and some people are claiming the rights of polyamorous marriage. Now, if that came before a court, and the court had a sustained legislation barring it, would that be an instance in which the court would be able to speak about what it thinks marriage in its rightful understanding would be? Is there any time in which you think the court could speak to that question here?
Not by way, in my judgment. I think this is a case where judicial restraint is required because the Constitution, we don't resolve the question of the definition and meaning of marriage at the constitutional level. I'd be perfectly content to see a constitutional amendment. In fact, many years ago, I advocated a constitutional amendment to create a federal uniform definition of marriage. But we have historically, just a matter of fact, historically treated marriage law as a state matter, not as a federal matter, and certainly not as a constitutional matter. So I don't think it would have been constitutionally sound for the Supreme Court to invalidate, say, a law from Massachusetts or California or some liberal state that that established same-sex marriage. I think the court would have had to abstain from intervening there. For the same reason, it should have abstained from interfering or intervening in the Obergefell case to invalidate traditional conjugal marriage laws. There are two competing understandings of marriage today. They both have sets of presuppositions, basic understandings. There's one that I think is right, the conjugal understanding of marriage. There's one that I think is wrong, which is an understanding of marriage is essentially reduced to sexual or romantic companionship or domestic partnership. That's the understanding of marriage you have to have in place if you want to reach the conclusion that same-sex partners can marry. But by the same logic, that would lead you to believe that 3 people or 5 people could be married in a polyamorous ensemble or something like that. But there are these competing understandings of marriage. And under our Constitution, it's really left to the states which of those to enact in their law, at least for now, unless we would change the Constitution, as I've advocated in the past doing. So I think the court, in upholding the conjugal marriage laws of of a state that chose to continue to embrace the conjugal conception of marriage could explain fully the reasons for it, why it makes sense, its rational basis, to use the legal lingo. But it should not try to resolve, in my judgment, the court would not be right to try to resolve the question one way or another, imposing a judgment one way or another on a state who had reached the opposite judgment. I'm curious about what Gerry thinks on this one.
Well, the one thing I would add, Robby, to your account is that although the Constitution doesn't refer to marriage, and no doubt if there had been a federal case in federal courts in the 19th century, as there were from time to time, the federal judges would find a definition of marriage in what they thought and would describe as the nature of things or the great unwritten law, but they would find a definition of marriage outside of the text. That's one thing. And the other thing to maybe keep in mind is that when Obergefell was decided, there was a fairly robust, long-standing and developed jurisprudence about what the court usually called freedom to marry, or the right to marry, or not so much the liberty to marry, but the right to marry. And there are cases all through the 20th century about the right to marry. And one observation that's probably worth making, and might have had some proper role in thinking through the same-sex marriage question at Obergefell, is that the federal right to marry, such as it was always attached to an understanding of marriage as the normative context for having sex and for having children. That's really what that right was about. Now, what I would add to what you were saying is that a state like Massachusetts, which decides to, in effect, legally abolish that understanding of marriage and replace it with a legal definition of marriage as a companionate marriage, my judgment is that there ought to be repercussions throughout the law if a state chooses to do that. Now, I use a strong term, abolish marriage and replace it with something else, but to signal that it's a very sharp departure for a state in 2004 or 2015 to have decided to adopt a companionate view of marriage. It's really to revolutionize that state's legal understanding of marriage, and revolutions usually have a lot of consequences. And I stress that because, as you know better than anybody really, in the run-up to Obergefell, maybe not so much in the aftermath actually, but in the run-up to Obergefell, the whole argument of the other side, of the same-sex marriage side, the side that you and I and Hadley opposed, but their whole argument was, all we're asking here is to be admitted to that institution as it presently exists. And it was really a matter, as they saw it and as they argued, really a matter of opening up the membership rolls to the existing thing, and would work no change in what marriage actually was. Now, I think that was, I don't know if that was made an argument in bad faith, but it was really not sound. So all I would add is that when you make marriage something very different from what it had been from time out of mind, it's going to have repercussions. So just for example, I don't think the federal government, let's just say the Social Security Administration, would be bound to recognize the same-sex marriages from Massachusetts as marriage.
Yeah, that I agree with.
Just for example. But on Obergefell, Robby, I'm wondering what you think. That unlike Roe, where I think the day after Roe, there was nearly a firestorm of opposition, and legislators, even in Congress, were vowing to correct it. We didn't see that with Obergefell. I dare say that the body politic more or less uneventfully digested Obergefell. Now, there have been very fruitful litigation. There's been very fruitful litigation about individual or group protection from same-sex marriage on free speech and free exercise grounds. But the thing itself, as I see it, seems to have passed into the culture and the law, and without anything like the tumult that greeted Roe. But I wonder if you have any thoughts about whether now, 10 years out, whether the timing is right, and if the timing is right, are there any pathways to explore to push back against Obergefell itself?
Well, there's no time like the present to begin. Now, there was this period after Obergefell where support for same-sex marriage, I think largely under the influence of the decision itself, expanded not only among Democrats and liberals, but also, of course, among Republicans and conservatives, and even and among independents. Um, it remains strong among Democrats in the latest polling I've seen. It remains pretty strong among independents, but it has weakened very substantially among Republicans. And there, I think, is an opening. So I think it's past time, really, to begin doing the public education work to restore the public's understanding of marriage as a genuinely conjugal partnership, to try to uh, help people to understand that whatever it is you've got, when you've got a form of relationship that's basically sexual romantic companionship or domestic partnership, it's not marriage. It doesn't do what historically marriage did for societies, especially when it comes to children. Um, I think that work, it's important for us to begin doing now, while we also keep the pressure up on the sheer baselessness, the sheer constitutional baselessness of the Obergefell decision. What it has in common with Roe versus Wade, and the fundamental constitutional reason it should go the way of Roe versus Wade, that is, be reversed, is that the Obergefell holding has no basis whatsoever. None, zero, zip, nada, in the text, the logical implications or presuppositions of the text, the structure, or the historical understanding of the Constitution. There's just no basis for what the court did in removing the issue from the legislative domain and establishing a national standard of same-sex marriage.
Now, can you imagine? Can you conceive a case in which that could be brought?
Oh,
Do you have
sure.
a sense of how?
It's easy to conceive.
Like,
Louisiana or
like,
Montana or Missouri simply reenacts conjugal marriage laws. The case is brought by someone or some people who were denied a marriage license under the new laws or revived old laws, and then the matter gets 4 votes. That they're 4 hard votes to get, but if you could get 4 votes for granting the certiorari petition, you'd have the case.
And you think you may find 5 votes, 5 members of the court willing to make that move to overturn
We don't
Obergefell?
at the moment, I
Well,
think. I don't think we do it.
well, actually, there are a couple of intervening moves. There was, as you know, we tried with Roger Severino's old Defense of Monogamous Marriage Act in place of DOMA. And I approached Paul Ryan over there. Paul Ryan's chief of staff said we'd go to the floor with this if we had anybody willing to introduce it. We had 2 conservatives, Republicans from the Midwest, who thought they'd be willing to do it, but they lost in primaries. But the point of it is, if the court sustained this bill to say we're confining this to a monogamous arrangement, if they sustain that, then they would overturn they overturn Windsor and say, no, the federal government may indeed have a role to play in legislating on marriage. If they overturned it, then they'd be virtually licensing polygamy.
Agreed.
And but then the second passage, it would be involved where, some of our friends would say, well, what's the problem with Masterpiece Baker? You can get a cake in many other places. And that's what the libertarians would argue. But the problem is they don't take seriously the conviction on the other side that this is morally wrong to deny this.
Yeah.
Therefore, those who deny it must be punished. So you could take that line. It's some provision to say that those institutions, Little Sisters of the Poor, other institutions, should not be penalized in federal law, withholding of benefits, suffer any penalties, simply for holding to the understanding long established that marriage involves a legal union between a man and a woman. And they just sort of make a step back with that to say it's not a wrong in the way other things are wrong. And after all, Anthony Kennedy thought he didn't want religious people treated in a contemptuous way. Maybe there's time to back. Maybe something of that kind
Yeah.
make the path in.
So in the book, in Seeking Truth and Speaking Truth, my new book that we're talking about today, there's a chapter. I wrote it with my former student, my superstar former student, Sharif Girgis, now professor of law at Notre Dame, about to become a visiting professor of law at Harvard. Sharif and I explain what Obergefell, in fact, should have said. And basically, there is, if they're interested, a roadmap for how justices could handle a new marriage case if one were brought before them coming up from a state that wanted to restore the traditional understanding of marriage as a conjugal partnership.
And if you took the lead on that, what would your lead sentence would be? That this had no constitutional ground?
Yeah, that Obergefell lacks any basis in the text, logic, structure, or historical understanding of the Constitution. It's a pure judicial manufacture.
So, Robby, if I may on this, I see a connection between the Dobbs decision then and a hypothetical world where Obergefell goes back to the legal understanding that prevailed after Windsor, because to me it seems like we are living in the abortion context in a Windsor world where states can legislate on the basis of marriage. States can legislate on their own understanding of abortion, and that's pretty much left up to the democratic process. But remember, Windsor was decided in 2013, and no fewer than 2 years later, Obergefell was decided by the Supreme Court as a move to perhaps assuage judicial conservatives that a world post Obergefell is still a world in which one can essentially defer to the democratic process. Is that a world where we, as conservative lawyers and those operating in those circles, we can make a compelling argument in marriage as a prudential move while still advocating that on abortion we are still very much not seeking that as a seeking to sort of enshrine Dobbs as an end game prudentially?
Well, of course, the Constitution can be revised. It's been formally amended 27 times, can be further amended. But under the Constitution we currently have, with its 27 amendments, there is, if we understand our Constitution correctly, a national rule when it comes to the protection of persons, which would include unborn persons. That rule, if honored, would exclude elective abortion, so that abortion legislation in the states could vary, but only on questions of the treatment of pregnancies where the object of the choice is not the destruction of the life of the child in the womb. So that's actually our Constitution today. Our Constitution today, with its 27 amendments, does not have a national definition of marriage or national understanding of what marriage is. We historically have chosen not to resolve that issue expressly or implicitly at the national level, at the constitutional level. So that's the difference between the two issues from a constitutional point of view. Now, both issues have right and wrong answers. I'm pretty sure I know what the right answers are on both of them from the moral point of view, but there's a different constitutional standing of the two questions. And that's just a matter of the positive law of the Constitution. The Constitution could address the marriage question. As I say, I have in the past argued for, that was a cover story of National Review once, my argument called the 28th Amendment. The 28th Amendment I was proposing was a national establishment of the conjugal understanding of marriage. To go back to Hadley's question earlier, battles, including cultural battles, including moral struggles, are never finally won or lost until one side essentially surrenders. And what happened, I think, in the marriage fight and leading up to Obergefell is gradually, and then not so gradually, a lot of Republicans and conservatives decided to surrender, either because they'd gone over to the other side or they decided it wasn't worth the fight. And now we're beginning actually to see the consequences of that, and they're not at all good. So I'd like to go back and revisit that. There are a lot of conservatives or so-called conservatives and a lot of Republicans that I'd like to say, hey, you guys, you really made a terrible mistake when you yielded on this issue. I don't know if you were doing it out of genuine conviction or you're just too tired to fight or what it is, but it was just a terrible, terrible mistake. You should not have surrendered. This was an issue worth fighting for. The family, based on marriage, based on the conjugal union of husband and wife, is the fundamental cell of society. You get that one wrong, it's going to have a lot of consequences, big repercussions,
See,
as Gerry said. So, time to go back, time to revisit it.
no, as we used to say, we found ourselves saying of late, has the argument against marriage as we understood it, has that argument ever been refuted? Well, if it hasn't, why has this issue
Yeah, I
ended?
mean, Sharif Girgis and Ryan Anderson and I wrote the book, What is Marriage? It began as a law review article
Fine,
in the
right,
Harvard Journal of Law and Public Policy, and then was expanded
right.
into a book. And a number of good reviews of that book have been published here and there. But I've seen no one even make a plausible effort to defeat the basic argument in the book. And I'll tell you why I think it probably can't be defeated. If you line up the traditional understanding of marriage as the conjugal union of husband and wife against the competitor, that is the idea of marriage as sexual romantic companionship or domestic partnership, if you opt for the latter, then it becomes impossible to explain the following things. Not only why marriage has to be between opposite sex partners and not same sex partners, but why it has to be two people and not three or four or five in a polyamorous union. Why it has to be closed, exclusive rather than open. Well, we're married, but we're going to have extramarital partners. Can't explain why it should be pledged to permanence rather than for a term of years, say 5 years renewable. Why should it be till death do us
Right,
part as opposed to 5 years renewable if what it is sexual
right, right.
romantic companionship or domestic partnership? And finally, it can't explain why the law has any interest in the issue at all. On the sexual romantic companionship understanding of marriage, the law has no more business recognizing or regulating marriages than it has recognizing and regulating bar mitzvahs or baptisms or other
Friendship,
culturally
other
popular
friendships.
religious events. So fundamentally, no one has been able to answer those objections. And I don't think anyone can because they are quite literally unanswerable.
But that is exactly the form in which I'd hoped the argument would be set forth, and the briefs had been written and heard. With the question, the points to make up the reasoning.
Well, I mean, they
But that
do
also,
assist if you make those points, which I've done in amicus briefs. If you make those points, they assist in showing the rationality of the conjugal understanding.
but also this brings us back to a point I thought I'd be using as the closing. I don't know if it's apt to use it now, but you bring us precisely back to the point about whether we, they had the courage to continue. But you remind me that when we had the marriage amendment in play, I remember I was at a meeting on the Hill, and our friend Rick Santorum came along. Remember him? And we sipped and fell into a chair next to mine. He said, "I just came out of a meeting of the Republican leadership on this issue. You wouldn't imagine the important leaders of the Republican movement who are looking at me and asking, why are you doing this? Why are you
They'd
doing
given
this?"
up. It didn't matter to them. It wasn't like something they cared about, like abolishing the minimum wage or the progressive income
And it's
tax or something that they thought
and,
was
and it's
really morally
embarrassing.
important.
And it's embarrassing. We're uncomfortable talking about this kind of thing. And we also get hate mail. When we're doing the Defense of Marriage Act, we got it through the House, and then Don Nichols in the Senate was getting tremors about this. And what was the problem? He didn't like the hate mail he was getting on this.
Yeah,
This
this
becomes
is the
another
this is of course the
ingredient.
fecklessness of so many politicians. Garrett, I see that my battery is about to die on us. This has been a wonderful
Okay, so
conversation. I really appreciate
let,
it, guys.
let me end with this point for Robbie's point. All right, is a closing point. This is in the chapter on, I think, Christianity and paganism. You recall Beto O'Rourke, you say, in Texas, in his charmingly hapless way, letting the cat out of the bag at the Democratic debate in 2016 that churches and other religious groups who refuse to go along with same-sex marriage should have their tax-exempt status revoked as punishment. You say they're determined that our children, or at least our grandchildren, will think the way they think, not the way we think. So permitting us to retreat to the functional equivalent of the monasteries, we can tend to gardens of our own families, to transmit to our children our own values, is not an option for them. And then you say in the closing lines, question before us is simply this. And this is a question you've been posing now persistently, going in and going, day in and day out. Can we muster the courage to be faithful, to bear witness boldly to truths that are unpopular among those controlling the levers of cultural, political, and economic power?